So good evening, everyone. My name is Karen Reneé. I'm the Executive Director for NAMI Central Texas, and you are at Mind Matters at Home. This evening session is called Where to Start, Social Security 101 for Mental Health. We're so excited to welcome Reneé Treviño with Texas RioGrande Legal Aid this evening. We had an opportunity to visit with her before we decided to do this session, and she is just chock full of all kinds of great information. She's such an amazing resource for our community, especially around this particular topic, which we know is one that families and individuals often come to us and have concerns, or if they've had issues with addressing this. So we're so excited to bring this topic to you this evening. And it is my great pleasure to welcome Reneé Treviño of Texas RioGrande Legal Aid. Reneé, I'm going to just turn it over to you and let you introduce yourself and get started. Thank you so much for joining us this evening.
Thank you for the opportunity. I greatly appreciate it. So as Karen said, my name is Reneé Treviño. I'm an attorney with Texas RioGrande Legal Aid. We have offices throughout South and West Texas, including one in Austin. At the end of the presentation will be the information about how to contact us if you need representation in a Social Security matter. Texas RioGrande Legal Aid represents people in a wide range of civil matters, not just public benefits, not just Social Security. And so if you have questions about the work we do or how to contact us, like I said, at the end of the presentation, there's a slide with our website, which is very simply www.trla.org. And it has information about how to contact us and the types of cases we do beyond just Social Security. So with that, a couple of things I wanted to do for housekeeping. As Karen said, I am open to answering questions as we go. What I would ask is make sure that the questions you're asking are in the same area that we're discussing at that point in time, or clarification questions. If I say something that isn't clear and you have a follow-up question, please feel free to ask. Please do not give me or the whole presentation, everybody who's attending this, personal information. We don't want to talk about specific cases because then you're giving up privileged personal health information or other information that we don't want to be broadcast publicly. The other thing, there will be a poll that's being posted by Christina. And the idea behind the poll is so that I know whether or not, when we get to how to evaluate whether or not somebody is disabled for Social Security benefits, should I focus more on adults or people who are transitioning from childhood to adulthood, which means in that 17 to 21 range as far as age, or do we have a substantial number of families who have children who would be in need of benefits through the Social Security Administration. So there is the poll. Please just let us know what category you fall into, and then I will try to focus the presentation more heavily on adults, people who are transitioning from childhood to adulthood, or we can spend some more time with children. There are slides about all three of these categories. It's just what I'm going to emphasize during my presentation. So with that, I'm going to go ahead and share my screen. Here we go. Let's see. Let's make sure I have the right screen up. Do you see the correct screen? All right. All right. So the presentation, I'm assuming everybody can see the bright Where to Start Social Security 101 for Mental Health. What I want to do, let's see, hold on just a second, I'm sorry. Let me get this going. All right, so learning objections. At the end of the presentation, what I want people to be able to do is understand the different disability benefits available through the Social Security Administration and distinguish between Social Security eligibility criteria for adults and children. If you walk away with this information on this slide, then I feel that I have accomplished something. If you believe that you're eligible for any type of government benefits, not just Social Security benefits, it could be SNAP, it could be VA benefits, it could be Medicaid. The most important thing is you have to apply for the benefits You have to complete an application, provide all the information and documents that are requested within the application. You have, if you start receiving benefits, you have to make sure that you report any changes in your household, your income, your assets, your residence, your telephone number. Those type of details are incredibly important when you're receiving benefits or applying for benefits. And then if you apply or you're receiving benefits and your benefits are, the application is denied, or if you're receiving benefits and they're terminated for some reason or reduced, appeal. So once again, if you can remember, appeal, report, and of course you have to start off by applying for benefits. That will be very important. Now, Social Security Administration, what I wanted to start off with are your basic rights. First of all, you have the right to file an application for benefits whenever you need them or when you believe you need them. An application should be filed as soon as possible. The date of the application may be, and usually is, the first date that you'd be eligible if you're determined to be disabled. If you're determined to have a mental health condition or physical condition that would entitle you to disabilities, that date of application is incredibly important. And for Social Security in particular, generally what I would say is you go to the local office and you can make an application at the local office. But all of the Social Security offices are closed to the public right now. So the best way to file an application is by doing it online. And I added the link so you know where to go to apply for disability benefits. The next really important right, and when I say due process rights, I want to go ahead and explain what that is. Due process is just like a person who's applying for benefits has to go through certain steps to have a valid application on file. The Social Security Administration has to follow certain steps in their consideration of your application for benefits as well as your continuing benefits. They can't terminate you. They can't suspend your benefits. They can't deny your benefits without following certain steps. That's all due process rights are. The requirement that an agency follow specific steps when making decisions relating to your benefits or your application for benefits. So after you make your application, you apply. If you believe that you have been wrongfully denied on your application, you have the right to file an appeal. The same is true if you're receiving benefits and your benefits are terminated or you receive a notice. You have to receive a notice. What is a notice? A notice is simply a letter that's going to come from the Social Security Administration. It must say the reason why your benefits are being denied or terminated or changed. Very important. You have to receive a letter that says what is going to happen with your benefits, the reason why it's going to happen, and have instructions on how to file an appeal. The reason I bring this up is right now we have seen quite a few cases where people have been receiving benefits and the Social Security Administration has determined you're no longer eligible for those benefits, or there is a period of time when you receive benefits that you are not eligible to receive, and they're not sending this notice letter. They're just sending a bill. If you're just sent a bill and told that you owe Social Security money, they haven't given you the proper notice of the reason why they are saying you have an overpayment and how to appeal it. So this is very important. Generally with Social Security Administration, there are 60-day period of time to appeal. It's very short, very short. It's not 2 months, it's 60 days, and it's 60 calendar days, not 60 business days. So if you get a decision you disagree with from the Social Security Administration, generally it's going to be a 60-day period to appeal. Now, what is different is if you're receiving benefits now and you receive a letter that says your benefits are going to be reduced or terminated, you have 10 days to ask that your benefits be continued pending the outcome of your appeal. Now, why is that important? It's very important because Social Security Administration pretty much can take as long as they want to make a determination on your appeal. And so if you're receiving benefits, it's your sole source of income, your sole source of health insurance, whether through Medicaid or Medicare, and you get a letter saying that Social Security intends to terminate your benefits or reduce your benefits, you want to get an appeal in within 10 days. And then you can ask that your benefits continue until you get a hearing or until your appeal is decided. And sometimes with Social Security, it can take 2 years to have an appeal heard if you have to go all the way to a hearing. So once again, very important. Remember, if you're receiving benefits and you get a notice that it'll be terminated or reduced, 10-day deadline. Once again, 10 calendar days. So very important deadline there. Now, your next right, you have the right to a legal representative if they're taking adverse action against you. Social Security doesn't have to appoint you a representative. That's not what I'm saying. You don't have a right to have counsel appointed to you. But there are, if you're doing a new application for benefits and you're being denied, there are many private attorneys that will represent people who are filing new applications for disability benefits. They'll do it without any fees unless they win your case. It's called contingency fee basis. They won't charge you unless they win. Now, if you have a termination of your benefits or a reduction of your benefits and overpayment, you're not going to be able to get a private attorney to represent you. And that's the reason that TRLA will prioritize representing people in suspensions, cessations, reductions, overpayment cases. Because legal aid pretty much is the last resort unless you're able to represent yourself. And just a note, I would not suggest you try to represent yourself before the Social Security Administration. It's supposed to be an informal, non-adversarial proceeding. However, it takes a certain level of expertise to be able to do these cases well. The last due process right, you have to remember, a Social Security decision is final and considered correct unless you appeal within the required timeline. If you don't appeal your case by the deadline, then you will have to start the application process from the beginning. So remember, those deadlines that I mentioned earlier are very important. Now, Social Security Administration, what are we going to talk about today? We're going to talk about SSI, Supplemental Security Income, RSDI, which is, we're going to focus on the disability insurance part of RSDI, Retirement Survivors Disability Insurance, and Medicare. Those are the benefits that are managed through the Social Security Administration. Now, we're only going to talk about disability benefits today. We're not going to talk about retirement. We're not going to talk about survivors benefits. So what's the difference between SSI, Supplemental Security Income Benefits, and Social Security Disability Insurance? This slide tells you, first of all, for both of them, in order to get disability benefits, period, from Social Security, you meet Social Security definition of disabled. For SSI, it is a need-based benefit. That means that what income you have and monthly income that comes in, and what financial resources you have, bank accounts, cars, property that's not homestead property, savings account, those type of things matter and will be evaluated when determining if you're eligible for SSI. The beauty of SSI is that it becomes with Medicaid. Medicaid is different from Medicare. Medicaid pays 100%. It pays the hospitalization, it pays doctor's visits, it pays the co-pays, the deductibles, it pays for prescription drugs. Medicaid pays for everything because the assumption is you're low income and the only way you're going to be able to pay for your health care is by having it paid for you through Medicaid. Now, the bad side or the downside of SSI is that there are very low limits as far as what the maximum benefit you can receive. For an individual who is disabled, the maximum amount of money you're going to be able to receive on a monthly basis is going to be $783 a month. If you're a couple and both of you are disabled, the maximum you're going to be able to receive from SSI is going to be $1,175 a month. And one of the ways you can tell if a person is receiving SSI is their check is going to be direct deposited on the first day of the month. Now, Social Security disability insurance, it's called many different things. It's called DIB, it's called Title II, it's called RSDI, it's called SSDI. But the bottom line is you have to be disabled, meet Social Security's definition of disability. And the reason you would qualify for disability insurance and not SSI is that you have a work history. And the work history is in the 10 years prior to becoming disabled. And we'll talk a little bit more about what that work history means in a few minutes. And then you get Medicare when you get disability insurance. And Medicare is like most private health insurance programs, where there's a premium you have to pay out every month that comes out of your Social Security check. It's about $145 a month for most people these days. There are copays and deductibles, and you have to enroll in a prescription drug program where you do have some copays for your prescription medications. So that's the basics of the difference between the two. Okay, there is a question about, is it better to have a private attorney to represent you when you apply? You can apply on your own, or you can have a private attorney do it. Some private attorneys will help you do the application. Most will say apply and see if you get granted benefits, and then if you don't get granted benefits, you get a denial letter, then you'd want to hire an attorney. Okay, so one of the other things that confuses people when receiving benefits is you can receive both SSI and disability insurance. And so I just wanted to have a slide about this. If you receive both, you'll get one check on the first of the month. That will be your SSI check, and you'll get Medicaid. And then if you receive disability insurance in addition to the SSI, you'll get a check either the third of the month, or you'll get your check on another one of the Wednesdays of the month. And you'll have Medicare. Now there's a Medicare card. Basically it's red, white, and blue and says Medicare on it. The Medicaid card is actually going to say My Texas Benefits, and it's going to be issued through the Texas Health and Human Services Commission. And so that's the way you tell the difference between whether or not you're getting Medicare or Medicaid, or both. You have two insurance cards. One says My Texas Benefits and one says Medicare, or do you have one or the other? Now, some basics about SSI. Like I said, it's a need-based program. So you have to meet the definition of disability. You actually have to reside in the United States. Now, that's different than having the proper immigration status to legally be in the United States and to be an immigrant who's eligible, a legal immigrant who's eligible to receive SSI. That's a different evaluation we're not going to spend time on. If you have specific questions, I can answer specific questions about immigration status. But when I say actual residence in the United States, you have to be a citizen or a legal permanent resident who actually lives in the United States to get SSI. Income, you have to be low income. And that includes both earned income and unearned income. Earned income comes from salaries. It comes from work. Unearned income can be anything from another form of benefits, or it could be your spouse or your parent and their earnings, depending on the parent. Depends. If you're a child, then your parent's income will count. If you're over 18 or over, your parent's income will not count as your income. It could be your spouse's income. It doesn't have to be a formal legal marriage for your spouse's income to count. If you're cohabitating with your partner and you're mutually supporting each other, then your partner, your domestic partner's income may count as yours, just so you know that. And then also I talked about resources, financial assets, and that is money that rolls over, or ownership of a non-homestead property. Your homestead never counts against you. Non-homestead property, someplace where you do not live, but that you own it or you have an ownership interest in it with other people, may count against you for purposes of SSI. And it's a very low resource limit. It's $2,000 for an individual, or for a couple it'd be $3,000. And yes, this does cover LGBTQI couples as well as heterosexual couples when I talk about spouses. Now, who qualifies for SSI in 2020? We're looking at a person with a permanent disability. I'm going to spend more time about what the definition of disability is, but something that's very important. It's going to be somebody who has a condition that's going to last at least 12 months or end in death. Adults and children both can be eligible for SSI. Elderly people can, people over 66 who are at retirement age can qualify for SSI if they're low income. And once again, I said they must physically reside in the United States. Disability insurance, what is it? It's a cash benefit, once again, just like SSI. It's for people who have a current work history. I touched on this earlier. And it's the 10 years prior to becoming disabled. You have to have worked at least 5 of the years prior to becoming disabled, or the date of onset is what Social Security calls it. It'll come with that Medicare. We talked about that already. And I gave you the different names. Now, one of the things about disability insurance, when I talk about working 10 years prior, you know, how much did you work in 10 years prior to becoming disabled? It's called insured status. So if you get a letter from Social Security saying you do not have insured status, that means they're questioning the number of years you worked prior to your application for disability benefits. That's all I really want to say about insured status right now. And then with insured status, it's how many quarters of work history you have. And so if you get a denial notice saying that you don't have sufficient quarters of work history, what I wanted to explain is basically you can have, there are 4 quarters in a whole, so you can have up to 4 quarters of work history in a year. And quarters of work history is not how many months you work, but rather how much you earn in a given year. And so for 2020, for example, 1 quarter of work history is $1,410. So if you earn $8,000 all in 1 month and you don't work the rest of the year, you have 4 quarters of work history. So once again, it's not how many months in the year you work, it's how much you earn in the year. So are we having problems with sound? If we are, let me know. Okay. Now, when will you have problems? You're receiving benefits now, or you've applied for benefits. There are different reasons you might be denied benefits or have your benefits terminated. First of all, there's a question about whether you're medically eligible for benefits, and a lot of today's presentation, most of today's presentation from here on out, is going to be talking about whether you're medically eligible for benefits. And then for SSI, we talked about the income and the resources and your physical residence. Those would be reasons to have SSI denied or terminated. And for disability insurance, the non-medical reasons are going to be either you don't have enough work history to qualify for disability insurance, or you're working. If you get disability insurance, whether it's SSI or disability insurance, if you get disability from Social Security, the assumption is you cannot work. And so if you are working, there's a whole different analysis we have to go through about whether or not the work you're doing is going to interfere with your ability to continue to receive or to be eligible to receive disability benefits. All right, so this chart looks confusing as anything, but it really isn't. What I have here is just the process. What happens if you apply for disability benefits and you either get granted or you get a notice of disapproved claim? You have 60 days to file an appeal of that decision. And that appeal is called a request for reconsideration. And you have to do it within 60 days, once again. If your request for reconsideration is denied, that's a paper review usually, you get a notice of reconsideration. And then you have 60 days to request an administrative law judge hearing. And then you're going to wait probably 12 to 24 months to get that administrative law judge hearing. After an administrative law judge hearing, there are other appeals, but they're more legal and legalese type of appeals, not a rehearing of the facts of your case, but the judge made a mistake in the way they made the decision. And so that's part of this chart also. Now, if you're somebody who's receiving benefits now, and they're going to try to terminate your benefits or reduce your benefits, you're going to get a notice of change of benefits. And then you're going to be able to request reconsideration. And then after you request reconsideration, it's the same process. You'll get either a granting of your reconsideration and continued benefits, or you'll get a notice of reconsideration that denies you benefits again. And you'll have to ask for an administrative law judge hearing. Now, the deadlines, I already mentioned this once, but I'm just going to go through them very quickly. If you're receiving benefits and you get a notice that your benefits are going to be terminated or reduced, you have 10 days to ask that your benefits continue at the same level. If for some reason you get a notice of overpayment, the Social Security Administration is saying that you receive benefits you're not eligible to receive, then that's an overpayment. And you can ask for an appeal within 30 days. And if you do that, you can also ask that you not have to pay back the overpayment until there's a final decision on your appeal. If you miss that 30-day deadline, then it's a 60-day deadline and they can start sending you billing notices. But the other deadline, if it's a new application, you get denied on your new application, or if you miss the 10-day deadline or 30-day deadline, you still have 60 days to file an appeal. But it's an absolute 60-day deadline to file the appeal of a decision you disagree with. Now, let's get into what the definition of disability is.
Excuse me, Reneé,
yes.
Because you were talking about the days, I've noticed that someone asked about, when does the 10 days start? The day you receive the mail or the day you mail it?
No,
they mail it.
It is a day on the letter. The date on the letter starts the time clock. Now, I always say, 10 days, 60 days. There is something called the mailing rule. I don't like emphasizing that at all, because then people will go to the later date and we don't want to risk missing a deadline. Mm-hmm. The mailing rule is that there's a presumption that it's going to take about 5 days for the mail to get to you. So technically it's 65 days, but don't think about 65 days. Just remember 60 days or 10 days.
Okay.
That way you don't run afoul of that.
And then one other quick question, so we were talking about income. Someone asked, does child support count as unearned income?
Yes, it does. Now, how it's going to count depends if the child who is getting some people get court orders when you get the child support order. If a person is living with disabilities, a child living with disabilities, sometimes the parent will be ordered to continue this child support after they turn 18. So there's a difference between how it's evaluated if you're a minor or if you're an adult, and if it's child support arrearages, meaning they're child support that weren't paid when they were supposed to be paid, and so now you're getting them after the child's 18 years old, that's counted differently. So yes, child support does count, but it varies on the facts of the situation, how it's counted. And that's how much of the child support is counted as income. All right, so now we're going to get into what the definition of disability is and how do you evaluate disability. Social Security considers whether a person has severe mental impairments is a word they use. And once again, I said they're expected they're expected to last at least 12 months or result in death. On the child support, if it's not actually paid, then it's not actually income. A child support order in which a parent is not receiving it or the child's not receiving the money is not counted as income. All right, so each impairment is a medical condition, and that medical yes.
I just wanted to interrupt because somebody asked an additional question in regards to child support. So let me just ask it while you were on that topic. So what if there's this child support that's ordered, but then they never actually get the payment? So in other words, they're failed child support payments.
If you don't get the payment, it's not income. Income is what you actually receive, because there are many people who have child support orders that never ever pay them. And so that will not be counted as income either for the child or the parent. that should be receiving it. It's if you receive it. If you run afoul of that and Social Security is trying to say that you're receiving income that you're not receiving, there are ways to prove that. One of the easiest ones is just get the report from the Texas Attorney General's office that says that it'll be an accounting of how much you're actually receiving, or the obligor, the person who's responsible for paying the child support, how much they're actually paying. The TANF question, we're getting into the weeds there, and if we have time, I'll go back to it.
Okay.
Don't let me forget, but I just don't want to veer off too far because I want to get into how to analyze whether or not you're disabled.
Okay.
All right. So with Social Security, it's very important you understand you're either 100% disabled or you're not disabled. There's not, it's, if you're familiar at all with veterans, they have percentages. You're 10% disabled, 15%, or excuse me, always 10s, 10, 20, 60, 80%, 100% disabled. Social Security, you're either disabled or you're not. There's no in between. Now, specifically, this is a huge issue, and this is why I have it in red. When we're representing people who have conditions they're living with, you're living with a mental illness in particular, we see often people who are self-medicating. I do not sit in judgment on that at all. I know the pros, the cons, but I have to tell you, as a lawyer who represents people in Social Security cases, a diagnosis or medical evidence, because everything about disability with Social Security is what is in your medical records. You have to get medical treatment. You have to go to the doctor. You have to have a clear medical record that shows how severe your condition is. What your diagnoses are, it's one thing, but you have to show how severe the conditions are that you live with, and you have to show that absent drug or alcohol use, your conditions would still be the same severity that limit you and prevent you from working. That's why I have this here. So what happens if you have a diagnosis of either drug addiction, substance abuse, substance dependence, alcohol dependence, whatever they want to call it within your medical records? If you have that in your medical records, then it becomes an issue at your hearing. It becomes an issue in determining whether or not you're disabled. So first will be an evaluation. In general, are you disabled? Do you meet Social Security's definition of disability? And we're going to get into the specifics of that. But after there's that first determination, are you disabled? Then they parse out whether or not the severity of your illness, the severity of your limitations and your ability to work, would they still be there? Would they still be as severe if you were not drinking or doing whatever type of medications that you might be abusing? And this is not just street drugs. If you've got a diagnosis of using unprescribed medications, prescribed medications or medications that are supposed to be prescribed, and you're abusing them, you have drug-seeking behavior, or you're taking medications that aren't prescribed to you, then you still have the substance abuse issue. So the questions that you want to ask is, would you still, and a claimant is the person who is either applying for benefits or is receiving benefits. For Social Security, you're called a claimant. Would you still be disabled if you stopped using drugs or alcohol? Would the medical symptoms still be as severe if you were not abusing drugs or alcohol? Would the limitations, what you're able to do, your ability to function, would it be as severely affected if you were not using drugs or alcohol? And one of the things that we look at in advocating for people who do have substance abuse problems would be, do we have a period of sobriety? Is there a period of time in which it's medically, and once again, it has to be medically documented, although this person was not using any type of medication or abusing any type of medications or street drugs, not abusing alcohol, would their illness be as severe during that period of time? So sometimes even, I would not encourage you, if you're trying to get disability benefits, you don't want to come up with this diagnosis, and you don't want to show continuing abuse of drugs or alcohol, because it will hurt your case. But there is always the argument that can be made that even during a period of sobriety that was documented, and it has to be more than a few weeks, we're talking about an extended period of time, the illness was still as severe. It affected you still as severely. So with that, we're going to talk about adults. So at this point, do we have a poll about, do we want to talk more about adults or people who are between 17 and 21 transitioning from a child standard to an adult standard, or do we want to spend more time on children? Okay, so we have adults with mental health conditions. That's where we're going to focus. I will touch on the other two, but I'm not going to spend as much time on it. Okay. All right. So with that, we're talking about people who are age 18 and older. It's called a 5-step sequential evaluation. So I have the 5 steps of the sequential evaluation. What a sequential evaluation means is you have to go from step 1. If you get past step 1, you get to go to step 2. If you don't get past step 1, you're sunk. So that's the way I'm going to talk about this. So the first thing that you have to deal with, step 1, is are you working? And the way Social Security Administration determines whether or not you're working is, are you engaged in substantial gainful activity, SGA? Now, what in the world does that mean? Substantial gainful activity is how much you earn in a month. And so there is a dollar amount for each year. In 2020, if you're claiming a disability because you're blind, it's $2,110. You can earn or you cannot earn more than that much or more. Otherwise, you don't get past step 1. If you're not blind or severely vision impaired, the amount is $1,260. So if you are able to work and earn more than $1,260 a month consistently, then you're not going to get past step 1, period. So that is what step 1 is. Are you working? And if you're working, and you're working 3 hours a week or 10 hours a week at minimum wage, you're not going to get to this level of substantial gainful activity. So you'll be able to say no. Now, a lot of people will ask me, should you try to work if you believe you're disabled? If you're going to apply, should you try to work? I say yes. Because if you're actually able to successfully work, you're going to earn more money than you're going to get from Social Security, period. And then also, if you try to work and you can obtain work, you can get work, but you can't keep work, and it's consistently shown in your earning history, because that's part of what's evaluated in this is your earning history, where you worked, how long you worked, how much you earned, and the 15 years prior to becoming disabled. If you're able to show that you're not able to consistently work, you can't keep a job, then that goes to show that there's something interfering with your ability to work. And I would argue shows that you get past step 1. Now, yes, these are complex rules. There's no doubt about it. That's why I'm saying, if you believe you're disabled, you meet the definition of disability for Social Security, get your application on file and get legal representation. It doesn't have to be an attorney, but what I would do is make sure, if you're going to a firm that does not, that you're going, we have paralegals that I would say represent clients as well as our attorneys represent clients. One of our best advocates at TRLA is a non-attorney. But make sure they have an attorney in the law firm. Make sure it's a law firm with an attorney there. And that's why I would not suggest you going to a hearing on your own. You need to try to get legal representation. Technically, you can represent yourself, but it is a very technical proceeding. If you can't remember all the places you worked, don't worry about it. Once again, Social Security is able to pull through the Texas Workforce Commission or whatever the equivalent is in other states. They're able to pull your work history. So it's work that's been reported to the Social Security Administration. On that topic though, just because it has not been reported to the Social Security Administration as work, you didn't work on the books, working off the books still counts as work. And the earnings from working off the books still counts as earnings. And I have tried to help people, I've had to counsel people that were working off the books and they thought they weren't going to get caught. Social Security has ways of finding out if you're working, even if it's off the books. So work is work and earnings are earnings. But you don't have to remember them all. When you have the questionnaires, it's going to ask for all these details. Fill out the questionnaires to the best of your ability. All right, step 2. Do you have severe impairments? What in the world is an impairment? An impairment's a diagnosis. Do you have a severe diagnosis or many severe diagnoses? Some people have a combination of physical diagnoses and mental health diagnoses. Most of our clients have some kind of combination of the two actually. But you can have purely mental health diagnoses and be able to receive disability benefits through Social Security. So the second step is just, do you have severe diagnoses? And I've read so many different decisions from after hearings before the Social Security Administration, and rarely does a judge say, no, you don't have severe diagnoses. What hurts or where people get stuck is not at step 2 with diagnoses, because having a diagnosis is one thing. The next question is step 3, and this is the hard one. Social Security has something they call the listings, and that's their definition of what being disabled is, how severe your impairment is. And so what I wanted to do is talk a little bit about these listings. And so the idea is you have a diagnosis. How severe is the diagnosis? Is it severe enough to meet Social Security's definition or listing for disabled under that condition? And I went ahead and gave you the link where you can go and look at what the listings are. They're pretty confusing unless you know how to read them, but I just wanted to give it to you as an opportunity if that's something you're interested in doing. Now, what is a listing? And I focus on mental health listings. So as you can see, there are neurocognitive disorders. That is somebody who has Alzheimer's, for example, or dementia. There are conditions usually that affect your memory, your ability to function intellectually later in life, or because you have a traumatic brain injury, you have memory issues, you have other issues because of that. Schizophrenia spectrum and other psychotic disorders, depressive bipolar disorders, intellectual disorders. Intellectual disorders would be, usually it's measured by a low IQ. And so that's where you'd get into intellectual disorders. There's anxiety, and there's the full list here of what the different categories do is show you an example of one of these. Something that we work with a lot with our clients is this 12.04 listing, which is for depression, bipolar, and related mood disorders. And the reason I'm showing you this is not to have you understand it necessarily as far as what this particular listing is, but to give you a guideline to let you kind of conceptualize what the analysis is. What are you looking at? The first part is the easy part. This A criteria, there's symptoms. So you have medical records. I told you it's really important to have medical treatment and medical records documenting what the illness is that you've been diagnosed with. So for depression, for example, it has the key symptoms of depression. And then if you have bipolar disorder, you're going to have the combination of the depressive symptoms and the manic symptoms, excuse me. And so those symptoms, when I'm going through medical records, getting ready for a hearing, I see these all over the place. And so it's the severity of these symptoms, not just that you have a depressed mood or that you have sleep disturbances, but how severe they are. And the way they are, so you have these symptoms, you have it documented. Great, you have a diagnosis and you have symptoms documented. But that's only the beginning of the battle. With disability through Social Security Administration, what you're really looking at is how your diagnoses, how your symptoms limit you. And that's this B criteria. And the B criteria is pretty much the same for all of the mental health listings, because you're looking at limitations and your ability to understand, remember, and apply information. And what we're talking about there are simple 1, 2, 3 repetitive instructions at work. Can you follow 1, 2, 3 repetitive instructions at work? Now, something that I always have to explain at this point is I'm an attorney. If I was in some type of catastrophic accident and I could no longer function as an attorney, that would not mean that I am disabled according to Social Security Administration. What they would want to know is, could I do any work? So I can't be an attorney, but could I flip burgers? I wouldn't be disabled according to the Social Security Administration. And that sounds extreme, but at times it really is that extreme. There's a lot of gray matter between the two. You know, there's a lot of gray space, but that is not an exaggeration. When I say an attorney who is in a traumatic injury, but can still follow simple 1, 2, 3 instructions, yes, you might still be able to do another job. And we're going to talk about that a little bit later. But the mental health limitations, what they focus on is a simple understand, remember, and apply information, follow instructions. Interact with others. That's how well you interact with supervisors, how well you interact with coworkers, how well you interact with the public. You know, are you going to have to work with the public? Concentration, persistence, and pace. Are you able to consistently do work? That's kind of the maintaining employment. Not only can you follow the 1, 2, 3 instructions, but can you consistently do that? And then adapt and manage oneself, or basically taking care of yourself. People with severe depression sometimes will go for days, weeks without bathing, won't take care of themselves as far as personal hygiene is the best example I can think of. There are other things in there, but that's really what we want to focus on. And that C criteria is you can't live outside maybe a group home or some type of an extremely structured environment. All right, so if you meet one of these definitions that are in the listings for disabled, then you win. Hearing's over, determination's over. You meet the definition of disability. Most people with a mental health diagnosis will not win at that level. What you have to go to is to the next step, and that is what we call step 4. Can you perform past relevant work? Now, what past relevant work is the work that you've done in the 15 years prior to becoming disabled. And considerations about what work would count as past relevant work is, was it a full-time or part-time job? How much did you earn each month? Remember when I talked about substantial gainful employment and how much you earn each month will determine at step 1? That's what we're talking about. Are you earning over that dollar amount each month? Otherwise, it's not past relevant work. It's not going to be work that's going to go against you being disabled. And then also, are you able to keep a job more than 3 months? The same job at a certain earning amount for at least 3 months. So there's a lot that goes into that, but if you don't meet a listing, their definition of disability medically, then the question is, are there other things that would prevent you from working? And that's this: you can't, even if you can get a job, you can't keep a job. And that's really the heart of past relevant work. If you're able to get a job, can you keep it and earn enough? All right, so we're running out of time. This hour's gone by really fast. The last step, and you only go to this last step if there's a determination that you cannot do your past relevant work, then the question is, do you have skills from the past 15 years that you can transfer into other types of jobs? And that's my example of being an attorney. And even though I can't be an attorney, which would be my past relevant work, can I use the skills that I have from being an attorney to do other types of work? So that's your 5-step sequential evaluation. Now, from there, I wanted to talk just a minute or two on each one of these. If you are somebody who has, or if you have a family member who has been receiving disability benefits from the Social Security Administration as a minor, 0 to 17 years, at 18 years old, every single person will be reevaluated because the children's standard for disability is much easier to meet than an adult standard. For children, it's how you are as a whole child, how you compare to other children. So if you are a child who either physically, intellectually, or due to mental health issues are behind other children by at least 2 years developmentally, then you may be determined to be disabled. So it's how you compare to other children. That's how a child's disability is evaluated. However, with adults, I said it before and I'll say it again. Can you work? Can you obtain work and maintain work? Can you get a job and keep a job? So that's what redeterminations are. And every single person who receives benefits as a child will face a redetermination at age 18. And that's where that 10-day deadline is really important. You get the letter, the date of the letter is June 10th or July 10th, tomorrow, let's say. Your deadline is July 20th to file a request for reconsideration and to ask for continuing benefits while you wait for the outcome of your appeal. If you do not do that, you will lose your monthly cash benefits and you will lose your health insurance through Medicaid or Medicare, depending, but it's really important. If you're receiving benefits, file that appeal within 10 days. Now, something that's important to talk about there is if you do get continuing benefits while you wait for your appeal to be heard, and in the end, there is a decision that that termination of your benefits was correct and within the law, you will have the responsibility to pay that money back. But, and this is a very important but, you can ask that overpayment be waived. And so if you file an appeal in good faith because you believe you still are disabled and you lose your appeal, you can ask that the Social Security Administration basically forgive that debt. And if you're able to show it was a good faith, and if you're appealing because you believe you're still disabled, it's a good faith appeal, and it would cause you financial hardship to have to pay it back. So do not hesitate to get continuing benefits if that's the only way you're going to have health insurance and the only way you're going to have monthly income, because there will be a way of requesting that the Social Security Administration forgive that debt if you lose your appeal. Now, I've talked about redeterminations as much as I need to. I do have the evaluation for children. I'm not going to talk about it because it would take too long. What I do want to talk about real quickly is reporting requirement and resources. This is incredibly important. And that is if you're receiving any form of benefits from the government, you're getting SSI, you're getting Social Security Disability Insurance, you're getting SNAP or food stamps, you're getting Medicaid, whatever it is. If you're getting any form of benefits from the government, you have the responsibility to report any change in income, financial resources, residence, telephone number, address. You have to report those changes. And it's within 10 days, whether it be Social Security Administration, what we're talking about today, or we're talking about Health and Human Services Commission, you have to report changes within 10 days. how do you report? For Social Security, I included the form, which is called a statement of claimant, and I gave you the link for that form. Or you can just put it in writing and send a letter to Social Security saying, I moved and this is my new address. Or I am now working and I'm earning this amount of money each month. Or if it's a child, my parents are working and they're earning this amount each month. But it's incredibly important. When you do it, try to get a receipt, try to send it certified mail with return receipt requested, which is the green card. When you send it certified mail through the post office, if and when the Social Security office is open, don't just put it in the drop box, sit and wait so you can get a receipt for it, showing that you reported what you were supposed to report. And then remember, the agencies lose things. So that's why you want to get a receipt. Don't assume that just because you submit something, they're going to properly attach it to your file. Keep a calendar. If you can't get a receipt, then at least keep a calendar showing what date you sent it or what date you dropped it off or who you gave it to or who you spoke to. Technically, you're supposed to be able to call Social Security and report changes by telephone also. If you do that, once again, put it on a calendar and get as much information about who you spoke to, when you spoke to them, and what you told them. Just a little bit more about what financial resources are, and I realize it's 8:30 right now.
It's 8:30, so
okay.
here's what I'd like to suggest. Let's go a little bit longer. If there are folks that need to log off, they can, and then they can, once they get the recording, they can always go back to this spot and go back to it. You're covering a lot of really important information, so I don't want to cut you short, so let's just do that. So anyone that wants to continue to stay on, we'll stay on a little bit longer so you can get through this piece. And then I do think that we're seeing a lot of questions that I feel like are very specific questions. I mean, they're really good questions. And one of the things that I'd like for you to think about and maybe address towards the end is there's a lot of very specific, nuanced questions. What's the best resource for getting help when you have those kinds of questions? So I'd love for you to kind of give us some ideas of where folks can have some of those questions answered as well.
Okay. Just on resources, when I talk about financial resources, I wanted to give you examples of what they would be. And financial resources affect SSI, the need-based benefit, not Social Security disability insurance. But in an abundance of caution, I would still report the resource changes. You inherit a piece of property, for example, you get a second car for the household, whatever it might be, I would still report that to Social Security just to make sure there's no question about whether or not you fulfilled your responsibilities to report changes. Let's see, what else? The other thing is you cannot gift anything. Say you do receive an inheritance, you're going to get a 1/3 interest. You and your 2 siblings are going to inherit your mother's home. You cannot say, I'm just going to give it to my sister because I don't want the resource to interrupt my SSI benefits. You cannot do that. If you receive some type of income or resource, you have the responsibility to report it. And if you're going to get rid of it, you have to get rid of it for fair market value. You have to be compensated. You have to be paid. If you're going to give it to your sister because you don't want to have that resource, she will have to pay you what it's worth, what your part of it is worth. Otherwise, you're looking at transferring a resource for less than fair market value. And that comes with a very stiff penalty. It can disqualify you from SSI for up to 3 years. Or if you're getting Medicaid, it can disqualify you up to 5 years from Medicaid. So don't think you can just give away something in order to qualify for benefits. You can't purposefully, what they say is you can't purposely impoverish yourself in order to qualify for benefits or to continue to qualify for benefits. The other thing, doctor's advocacy, everybody asks, well, can I get my doctor to write me a letter? This is the last thing I wanted to talk about. Yes, But most doctors are used to saying, my client is disabled, you should give them benefits. Doctors write orders, people follow their orders. That is not the way Social Security works. You have to have the medical records that support the doctor's opinion letter, and the doctor's opinion letter should have certain components. And that should be how long they've been treating you, what your diagnoses are, what the severity of your diagnoses are, what medications have worked and have not worked, if you can get that, how responsive you are to treatment, and what's your prognosis, and how do your diagnoses affect you and limit you. So with that, in Austin, I said we have an office. So it's on North I-35 at 51st Street. All of our offices, our physical offices, are closed to the public because of the pandemic we're living through. However, we all are still working. As you can tell, I'm at my house at my dining room table. This is my new office. And if you call, oh my gosh, it's 1-888-988-9996. I apologize for that. I'll put the number here. So it's 1-888-988-9996. That is what we call our telephone access to justice. We have people working it from 9 a.m. to 5 p.m. If you call in, they'll do an evaluation if you're financially eligible for our benefits, or for our services rather. We do only represent low-income people. And then once we get through that part, we'll do a substantive, or what are the facts of your case and what help do you need? That will all be done over the telephone. And then from that person, which is usually a paralegal, an attorney that specializes in that area of the law is going to review your case and make a determination if we're to be able to represent you, or if we're not going to be able to represent you, give you concrete legal advice or a referral to somebody who may be able to represent you. So I apologize for going over time. If you have questions, I'm willing to stay if you have questions. I know I didn't answer all the questions in the chat, so just tell me what you'd like to do at this point.
I think at this point, looking through the questions, like I'm noticing at least one question that's probably, some of these folks would probably benefit from just calling that number, I think, and talking to someone. So I think you answered the question that I had. So regards to that. So I think folks can do that. And just so you know, we will be, again, sending you a follow-up email that has the link to this entire presentation, as well as, thank you, Reneé, for being so gracious. She has allowed us to also share her slides, and that will include all of the slides, including the ones that she didn't get a chance to cover. So you will get that information. Use that number that she provided, that 1-888-988-9996 number, and I think that's going to be a great resource. And then I just found, like, there was one question that was asked towards the end here that I thought was a good one as well. If parents, and because we hear this one a lot, if parents are financially supporting an adult child with a mental health illness, does that count as income for that adult child?
It does, but it is very different from a minor child. So with what happens with an adult, parents who are supporting an adult child, what would be very important is if you're providing free shelter and food, so a place to live and basic food, they're living in your home with you, for example, or you're paying their rent directly to the landlord, then that's called in-kind income. And the way that's calculated is if the maximum SSI benefit, let's say that's SSI benefit, because that's the one that's need-based, and that's where income counts, unearned income counts, as well as earned income. So what would happen is there would be a 1/3 reduction of that $783. So I think it's $522 would be what that adult child would be eligible for. The important thing is, if they're living with you, then it's obviously in kind. You're not giving them cash. If you're paying the rent for that adult child, you want to pay it directly to the landlord. You want no cash going from parent to adult child, because then that is income, and it's going to count not, basically dollar for dollar. There's a $65 that won't count, and then it's dollar for dollar. No, excuse me. If it's under income, $20 will not count. They'll let you get $20 without accounting if it's unearned income, and then it's dollar for dollar will reduce your SSI benefits.
And then I'm gonna
go ahead.
I'm sorry. No, I was just going to ask then just one last question, and then we'll let everyone go, because I thought this was a good question as well. And I think we certainly hear this. I mean, looking at all your slides, hearing you cover all the information that you're covering, I mean, this is really very complex. There's a lot of nuances. It's a little overwhelming at times. And someone pointed out, so, you know, obviously the whole process is a little bit overwhelming, but then if you also perchance have a severe neurocognitive disorder, a very serious mental illness, you know, can someone else apply for you? You know, if someone's not able to represent themselves, is there someone that can help them or apply for them and walk them through the process?
Yes, somebody else can help you do it. Right now, really, the main way to apply for Social Security is online. You can start the process and it'll give you a password so you can re-enter if you're not able to sit down for 2 hours and do it. With TRLA, if we have somebody who cannot complete the process, generally we say apply yourself. If you get denied, come to us. If it's a person who cannot complete the process themselves, but we're trying very hard to do, and I'm not saying we're able to do it for everybody, but what we're trying very hard to do is help people as a limited service actually do the online application. And then we will send the documents the person needs to sign, because you have to do the online application, you have to fill out all this information online. And then you have to print out some documents and you have to sign their documents, and then you have to mail them to Social Security. So what we're trying to do, and like I said, we can't do this for everybody. We are trying to help people who do not have the technological capacity to do the application online, or they do have the neurocognitive intellectual functioning, or just the severity of their illness prevents them from doing the application. We will try to do it online by telephone with you, and then we'll send you the forms you need to sign to and help you submit it. Now, one of the other things, I know there was a question about, you know, there's a lot of rules and there's all this, it's overwhelming. Social Security has a website, and I posted in the chat the website. It's www.socialsecurity.gov. The reason I did that is you can do basic searches online for most of your questions. If it's SSI specific, there's something called the SSI handbook, and it's very user-friendly, and it'll answer very basic questions. You can go delve deep into the Code of Federal Regulations, which are federal rules about Social Security. All those are on that website, or you can ask more general questions. You can load up different forms, and that's where you also file your application. You can also file your appeals online, and I gave the link as part of the presentation about how to file an appeal online.
Okay. Well, Reneé, you have been incredibly helpful, and you've given us a lot of really great information. And I know a number of people asked again about the slides, so I just want to again confirm that we will be sharing that with everyone. And we just want to thank you. And this is the first time we've ever had an opportunity to do something with someone from Texas RioGrande Legal Aid. We know that you do good work, but we're incredibly grateful for the opportunity and hoping to bring you back again, because I know when we visited, we talked about a number of different topics that you're able to inform our folks on. So we're looking forward to maybe doing some future topics with you. So we just want to thank you, and we want to thank everyone that joined us this evening. I hope you found this as helpful as I did. I really learned a lot. And everyone, be healthy, be well, take good care of yourselves. And we look forward to seeing you again then. We'll be back July 23rd. That'll be in the afternoon at 2 o'clock when we'll be talking on the topic of Black health, mental health matters, and about some of the impacts of trauma in that particular community. So we look forward to seeing you again then. Thanks so much. Bye-bye.
Thank you.